supposed suggestion and how he interpreted the words. I think the testimony of even Mr. Osterman yesterday sort of indicated, well, I think maybe he just interpreted it some way, but here's what he said. So actually, whether or not the defendant knows better or would have any reason to know better is relevant. Cross-examination, again, Mr. O'Mara's cross-examination of Detective Serino about the trade secrets sort of thing. The statements in the interview, especially his written statement. The idea that he has been exposed to materials on and taken a course that covered how to be a good witness. And this is all, again, the coursework intertwined with the other evidence of his ambition and his activity. And not that there's anything wrong with that ambition, but it certainly goes to the defendant's state of mind. He has applied to be a police officer before. He still wants to be one, according to some of his homework assignments. The homework assignments are relevant because that's the sort of thing that he did in the class he was involved. This isn't sort of some passive non-thing, especially the one that tells you why he wants to take in the class in the first place. The idea that he wants to go right along with police, that he wants to be an affirmative participant in what's going on. Again, not that it's bad, but it's relevant. I will also point out that there is a relevance as to the defendant's particular knowledge. The state argued in a case as part of its identification theory, and I'm now on to the Williamson case, which I think is the next one, that the evidence demonstrated in that the gunman had knowledge of legal forms. The killer in that case had legal forms. And as proof, the state sought to submit that the defendant had actually filled out and knew how to fill out other legal forms, and the court held that that was admissible. Relevant to the issue of, in that case, the identity, and they agreed that the introduction was not 90.403 material. And I will point out, I want to address 403 for just a moment. Rule 403 says the danger of unfair prejudice must substantially outweigh any probative value. I have yet to hear how any of these documents are supposedly prejudicial, let alone unfairly prejudicial to the defendant to that kind of degree. They have asserted none. They are clearly probative of his experience, his desires, his state of mind as of the time of this killing. And so, Your Honor, as it relates to each exhibit in particular, State's Exhibit 209, which is simply the fact that he had completed enough coursework to be applying for a degree at the very term that he would have been completing when this homicide occurred. Two of the particular courses he took, criminal investigation and criminal litigation, which bear in a number of ways on his behavior in this particular incident, as well as his behavior in other contexts, and the fact that he would know, and there's nothing secret about this, the idea is that he, if he were ever involved in this kind of situation, he would know what there might be asked of him, done with certain pieces of evidence, what he might be asked about, the type of questions or the way that they might be asked. He would know these things, or at least would have reason to know these things. Again, as it relates to the prior application for the police force, as well as the application to ride along with the Sanford police force, it just, again, it shows his continuing involvement, and this is over a period of time. This is not some Johnny-come-lately to this idea. This is a person who has decided that he wants to not only do this, but he wants to receive a degree in it. And there's nothing wrong with any of that, but it certainly tells us a little bit about the defendant's state of mind when he encountered this individual that he automatically, the first words out of his mouth were, a suspicious guy. So the state believes that all those 5 exhibits are relevant for not just one reason, but a number of them. None of them are conceivably more prejudicial than they are probative. And we've made efforts to redact the personal information so none of that would get out.
There's none of the bad credit or any type of good credit or any personal information that would...
The personal information we took I screened it first, I asked the defense to screen it too, and the clerk finished the job, and I think between us we pretty much have got everything. The thing that Mr. O'Mara referred to was a summary as to why the application was denied, which does cite COLL credit history. If that
would need to be redacted.
I'm fine if the defense wants that. Again, if they want to avoid the implication that he was denied for any other reason, I understand that as well. So it is there, but I have no objection if that particular part of it gets redacted. And as far as the authentication of it, it is the letter actually, the research was done.
Just for the record, that's part of 209? No,
I'm
that's
sorry,
part of 211.
It's part of 211, Your Honor. The letter in question and the research was done by Lieutenant Scott Kearns of the Prince William, Virginia Police, and he is the witness who would be testifying about it. They do not keep the full application for any more than their statutory required period, and so the record as to the application doesn't exist, but the record that he applied and was rejected does, because Lieutenant Kearns wrote the letter. As far as whether the defendant had to, I want to address the argument that he somehow had to, we have to establish that he particularly knew about or was present in a certain class when a certain subject came up. I believe, again, that overstates the idea of relevance. The idea of relevance is that the defendant expressed an interest in this type of course. He paid for it. He took it. He was seeking a degree in it. And the notion that a college guy never misses a class, and one of them was even an online course where you'd have to interact in a chat board forum and things of that nature. The idea that you have to establish that he read a particular word in a book, I think, again, way overstates the idea of relevance here. The fact is he sought out and then, of course, had access to and was obliged to get a grade about, and he got an A in litigation, I think a B in investigation. That he had to do all those things and that these were his choices. So I don't think the state has to necessarily prove that the professor put eyeballs on him and had him sitting in the seat in order to make his choice of course and the material that would be covered in that course relevant to the state's theory of the case.
Thank you. Mr. O'Mara?
First of all, of course, they're calling this witness for some type of impeachment, but beyond that, Your Honor, having just been given 10 or 12 cases from the state, I would ask for a couple of hours to actually,
Sir, I gave you all night last night and a half hour yesterday, and I told both sides I understood your arguments, and I needed you to be prepared to come with the case law to support your arguments. So
may I finish my request? May I finish my request? So
may
that it's
I
on the
finish?
record?
I will let you finish, of course. The purpose of having this argument this morning at 8:30 was to give both sides the opportunity to provide to the court case law that would support their position. I have a jury sitting back there. This issue, I spent the night looking at it. Both parties spent the night looking at it. Let me hear your argument.
My request is for a continuance for a couple of hours because I've just been given about a dozen cases from the state that seem somewhat instructive to the court, but I've noticed already, just as Williamson and other cases, just in the moment I've looked at it here, that there are distinguished characteristics to those cases that I need to have an opportunity to present to the court. So, to the extent the court is going to rely at all on the state's argument and the case law that I have not had a chance to review, then I would ask for some time to do that on my client's behalf.
Well, again, Mr. O'Mara, in all due respect, we started this issue yesterday afternoon. I had the jury out for a half hour so you could have time to research this issue. You came back and told me that you needed overnight because it wasn't enough time. Recessed early yesterday, provided counsel for both sides overnight to research this issue, and I will listen to any cases that you have to support your position. But I'm not continuing this matter.
With that in mind, Your Honor, the state's cases to date seem to show, first of all, I would think that it is in fact a 404-2 argument because if in fact they are trying to bring in acts that they are then going to argue the relevancy to the jury, then they are in fact 404 attack on my client's credibility, and they can't slide past their requirement to give us notice of these prior acts 10 days before trial by suggesting, well, that they're not really bad acts. We're just going to argue that they're bad acts. Well, actually what they're going to argue is that they suggest, as the state has now acknowledged, that these acts somehow support their theory of defense for second-degree murder. So they can say to you that they're not really bad acts because they don't want to have a 404-2 analysis of it, but that's exactly why they're putting them in. They are putting them in so they can turn them into seething bad acts, subtle but seething bad acts of my client. So they can't color it one way to bypass 404-2 and then color it another way in their argument to the jury. If, in fact, they are going to argue to this jury that these are evidence of knowledge, of forethought, of knowledge which was the foundation for his ill will and hatred, that he had this available, then it is, in fact, a 404-2 analysis. They violated their requirement under the rule to give us 10 days' notice ahead of time. That then demands a Richardson inquiry as to that issue. So in that sense, they can argue to you that it's not 404-2, but it, in fact, is. And let's look at why. The case law that they have suggested to you to date, today, is all, in effect, prior bad acts under 404-2. An affair to show anger and hostility towards a person, the wife, ex-wife he ended up killing. Hiding money in the Cayman Islands to avoid child support. A bad act to show what he was doing to presume the ongoing battle between the two. The sudden deterioration of the relationship between the defendant and the alleged victim. Again, the bad act information, 404-2. What they're saying is, well, it doesn't look bad on its surface, Judge, so ignore 404, but we're going to argue that it's bad. We're going to argue that he was a seething cop wannabe and argue that to the jury. They can't slide, and I would suggest to the court, they can't slide by the evidence code and suggest that this isn't exactly what they're going to do. So I would ask again that they somehow relate this to some theory of the case factually. What does the state say happened on the night of February 26th that makes this information relevant to prove a fact? Do they say that he ran after him? Do they say that he tracked him down? There's no evidence to support that, not to date, certainly, and I don't think that they're going to be presenting any more factual evidence in that regard. So in effect, what they're doing is trying to subtly present evidence through you, through this argument and your ruling, that they will then turn into 404B evidence to the court, and that's not allowable, which is why we have 403, to look at it and say what it is that they're trying to do and what purpose is. So if, in fact, they're going to bring in prior good acts of my client, which they can't do either, by the way, unless they show a connectivity, a relevance to some theory of their case, and I would again ask that they proffer both the theory and further they proffer the actual evidence, because it is still my position that if, in fact, they're going to say my client knew of stand your ground, and that's somehow impeachment, again, on, I believe, a collateral issue, an improper impeachment, but if they're going to say that as a foundation bringing in this evidence, then at least they should proffer it to you for you to make a primary or threshold determination that this is, in fact, relevant evidence, that he was in the class, that he did know about it. What they're doing, and I was only half kidding when I said Valentine's in first grade. There's an enormous amount of information that we carry on with us as adults. But we're not held to know it completely and fully in a criminal courtroom in a second-degree murder case unless you can connect those dots, unless you can say without question, yes. In all of the cases, including Williamson, and I just had a chance to look at, the court looked at it and said, as to that particular issue, where they connected up, this form he filled out is very relevant to this fact, and there is a connection, we will allow it. The problem here is that we do not have any connection. We do not have any from the state. We have a great argument that their theory is he wants to be a cop. And somehow, the fact that he wants to be a cop and actually went to a class, we should be able to argue that he wants to be a cop. Well, if in fact they're going to limit themselves before you, that they're only going to argue he wants to be a cop, then it's not relevant. If in fact what they're going to try and argue is he's a seething cop wannabe, then they have to show that there is a connectivity between the two to make it relevant, and they failed to. And I renew my request for the proffer of the evidence so we can see actually what these professors are going to say before a jury hears it, because if in fact it gets to the jury, we can unring that bell, and again request more additional, additional time to address this.
Okay, thank you very much. Did you have something further you wanted to say?
If I could, Your Honor, I just want to refer back to two cases, and that's Marquardt and Holmes, and I'll quote briefly from Marquardt. Evidence showing familiarity with or proficiency in tactics is not by itself evidence of bad character, nor is it similar fact evidence of another crime. In that case, again, that was the martial arts type tactics. So, and Holmes, of course, we covered very extensively when we covered, but this is inextricably intertwined evidence to various things. As far as proffering the evidence, well, I videotaped one of the professors and gave the defense that. As far as the Richardson inquiry goes, they've had certainly access to all the college materials and everything else. They've had the records custodian and his transcripts and everything else have been listed for months. In fact, the defense was so on notice of all this stuff that they filed a motion in limine before this court seeking to exclude any mention of the phrase wannabe cop or anything like that. So to now come in and say, oh, we're surprised by all of this, we have no idea, these people have been listed for a long time. The only exception to that, really, is the homework assignments that when I followed up with Professor Jackson, he provided, it was either a week or a week and a half ago, somewhere around that, and I provided them the day I got them. That's really the only thing that hasn't been, and I will point out, Professor Jackson's been listed for quite some time and has never been elected to be deposed. So I simply say that the effort here to now, and I'm glad I brought the picture along, is being, as we expected, to try to shoehorn this from 401, 402 to relevance to 403, more prejudicial and probative, to now we're at 404. And what that tells me is that the defense doesn't really know what the proper objection is because there isn't one.
Okay, thank you. I have reviewed the evidence code. I've reviewed case law, and after listening to the arguments by the counsel today, the court makes a determination that the testimony bears directly on an issue in this case. Therefore, testimony is substantive and the objections are overruled. Do you need a few minutes to get your first witness ready?
There was an issue regarding the redaction of the
credit
application.
As well as I just needed to know whether the course book still you want that included or not.
The concern with the redaction, Your Honor, is though it is distasteful to have that information before the jury, taking it out will simply allow speculation that there was some other reason why, rather than just the fact that he had bad credit. So in the Hobson's choice of having to allow the jury to know that my client had bad credit, which I think is completely inappropriate.
Does it say the words bad
Yes.
credit? What if we just took out bad and just put
Let me
credit?
add one other to this. The lieutenant will say that that is the reason that was listed, and that could mean one of two things. It could mean there was in fact a credit problem, and it could mean that the defendant was not candid about his credit reporting. Either one of those I don't think is an inference the defense wants drawn, but I'll defer to their wishes on that.
I'm in a Hobson's choice. I need to decide
Well,
between...
what if we took out the word bad and just put credit as an issue and left it there?
It says the same thing to the jury.
This wouldn't
Could be they weren't able to verify the credit. Doesn't mean it's bad or good or indifferent.
Actually, if they want to strike the whole last page of it, that's also
Well,
fine.
There you go. Then the last page will be stricken. Issue not an issue. They're figuring that out. We'll take a 10-minute recess. Court will be back in 10 minutes.
Oh, you're done.